Good morning, everybody. Welcome to the July 31st, 2025 California Board of Behavioral Sciences Policy and Advocacy Committee meeting. My name is Chris Jones. I'm chairperson of the committee. Before we convene, I would like to remind everyone present that the board is a consumer protection agency charged with administering and enforcing the board's laws. When the protection of the public is inconsistent with other interests sought to be promoted, the protection of the public shall be paramount. The committee will meet by teleconference in accordance with Government Code Section 11123.5. Committee members will participate remotely from private, non-public sites. The public may participate remotely or in person at DECA headquarters at 1747 North Market Boulevard, Suite 182. I will announce when we are accepting public comment on the various issues, and the meeting moderator will open the lines as appropriate. Each commentator will have 3 minutes to comment. Moderator, would you please provide the audience with instructions on how they may participate during the meeting at the appropriate times?
Certainly. At the appropriate times when public comment is requested, we will display the slide, and users can look at the bottom of their WebEx screen for the raise hand icon. If you are on a mobile device, that hand icon might be behind the three-dot other options on your mobile device. And click that to raise your hand. We'll take comments in the order received, and each speaker will have 3 minutes with a 15-second warning. That will be the process, and I return the meeting to you, Chair Jones.
Thank you. I would now like to call the meeting to order and ask Christina to call roll to establish a quorum.
Can you all hear me okay?
Yes.
Okay, Chris Jones,
Here.
Kelly Ronasinghe,
Here.
Wendy Strack,
Present, public member.
John Sovek,
John Sovek, LMFT, pronouns he, him, present.
Would you prefer I?
You go ahead. We have a quorum. You can go proceed.
Perfect. Thank you. Board staff, would you please introduce yourselves?
Good morning. Steve Sodergren, Board of Behavioral Sciences Executive Officer.
Roseanne Helms, Legislative Manager for the Board.
Christy Berger, Regulatory Manager for the Board.
Sarita Risso, Special Projects and Research Analyst for the Board.
Marlon McManus, Assistant Executive Officer for the Board.
Christy Shields, Regulations Counsel for the Board. I'll go ahead and turn on your camera.
Is that everybody?
Sabina Knight, Legal Counsel for the Board.
All right.
Nina Kitamura, Administrative Analyst for the Board. And I'd like to introduce one of our newer employees here. She's going to substitute for me at the board meeting, so I thought I'd bring her in today and let you meet her.
I'm Rachel Lanzoni, Budget Analyst for the Board. And nice
Excellent.
to meet you.
Welcome.
That should be it. And can you hear us all pretty good? I just want to make sure, confirm that.
Yeah.
Okay. Good.
Okay, now it's time for the public to introduce themselves if they would like. This is voluntary. Is there anyone in the audience that would like to introduce themselves? Moderator?
I'll move, but
Yes, we do have volunteers. Suzette Garcia, I'll send you a request to unmute your mic.
minus one.
Over here.
Okay.
Hello, yes, this is Suzette Garcia, the Executive Director of CalPEC, California's Association for Licensed Professional Counselors.
Thank you. And I believe that's the only, we do have another. And for Bindu Mukalamala, I'm going to send you a request to unmute. And Bindu, you should see a pop-up and you can click unmute me. All right, I sent one more request. And then Dr. Jasmine Smith, I'm going to send you a request to unmute.
Hi, good morning. So my name is Dr. Jasmine Smith. I'm a licensed clinical social worker, and I serve as the co-interim executive director of the National Association of Social Workers for the California chapter. Bindu is our policy manager, so she is also with the NASW California chapter.
Super. Thank you very much.
Okay.
And I believe that is it for the introductions.
Thank
We
you.
have one in-house.
Oh,
Yep.
Yeah.
all right.
Hello, here I am, Chauncey Ezrin, California Association of Marriage and Family Therapists.
And that's
Excellent.
it for here.
Thank you.
Perfect. Thank you. Welcome, everybody. The first agenda item is discussion and possible approval of the August 9th, 2024 and January 24th, 2025 committee meeting minutes. Does any member wish to remove or edit any items from that consent calendar or those consent calendars? Oh, okay. Then do we have a motion to approve the minutes?
This is
Move to approve the minutes for August 9th, 2024 and January 24th, 2025.
Thank you, John. Do I have a second?
I'll second.
Thank you, Wendy. Any further discussion from our committee? Do we have any discussion from our in-house participant?
No.
How about any comments or discussion from our remote participants?
This is the moderator. If anyone would like to make a comment on either on the motion or either set of minutes, you may raise your hand by clicking on the hand icon. Those using a mobile device may need to click on the three-dot other options to get to the hand icon. And our call-in users can press *3 to raise their hand. Instructions are on the screen. Are there any comments on the motion or either set of minutes? I do not see any requests for comment. I'll turn the meeting back to you, Chair Jones.
Thank you. All right, Christina, would you please take the vote?
Yes. Chris Jones,
Yes.
Kelly Ranasigi,
Yes.
Wendy Stratt,
Yes.
John Sovek.
Yes.
Motion carries.
Wonderful. Thank you. Next on the agenda is the discussion and possible recommendation to initiate a rulemaking to amend the board's experience requirements for licensed educational psychologists. Roseanne, would you provide us with the overview, please?
Yes, I'll turn it over to her. Thank you. Can you guys hear me okay? Uh-oh.
Yeah.
Oh, okay, yes, good. Okay. I'm used to having a microphone. Okay, so we're talking about amendments to the LEP regulations. And we've discussed potential rulemaking changes at a couple of prior committee meetings. It's been a while though, so we've been working on this in the background. And so we first had some legislation, and that's currently pending, correct?
Yes.
And so I'm going to go over just really quickly the requirements for licensure and then what's going to be changing with this bill should it be signed, which we do expect it will be. So currently it's 60 semester hours of postgraduate work in pupil personnel services, 2 years full-time or equivalent experience as a credentialed school psychologist, and one of the following. So 1 year of supervised professional experience in an accredited school psychology program, and 1 additional year of full-time or equivalent experience as a credentialed school psychologist in the public schools under the direction of an LEP. The proposed amendments to statute through SB 775 fall into 3 categories. 1 is specifying experience requirements in greater detail. So we're going to do some things to make it a little easier for the evaluators to evaluate the amount of time that someone has spent as a credentialed school psychologist. Right now it just says full-time or equivalent to full-time. It doesn't really say what that means. It talks about years, but not, currently we interpret that as school year. So we're making some of this stuff much clearer in the statute, talking about school terms. We're specifying that experience has to be no more than 6 years old prior to filing the application for licensure. And clarifying that for California credential holders, the additional school term of additional experience must be under the direction of an LEP with a California license. And then we're clarifying some requirements for in-state versus out-of-state school psychologists, and then adding an age limit to the passing score on the LEP exam. So that's the pending legislation. So what we're looking at for the proposed amendments to the regulations, these would be run after the statutory changes are enacted into law. The proposed changes that we want to talk about today is striking some language that would be covered by statute. So it's pretty simple. If the bill passes, so there's that. And then a big piece of what we're going to be fleshing out in the regs is for the 2 years of full-time or equivalent to full-time experience as a school psychologist. Currently statute says it's required to be in the public schools. We do have existing regulations that say the board may accept experience gained in a private or parochial school at the board's discretion. But the regulation doesn't define how the board shall apply its discretion, and this needs to be specified. What the regs would do is clarify under what circumstances experience would be allowed in parochial and private schools. We formulated the text considering the fact that special education services are often limited for students with disabilities who are parentally placed in a private or parochial school. Not always. As Chris has explained to me, that some schools are private schools are actually designed for kids with disabilities. So we will get some people who, have that qualifying experience. But there is concern because under federal law and regulations, no child with a disability that's parentally placed in a private school has an individual right to receive some or all of the special education and related services that the child would receive if enrolled in a public school. So that means that the school psychologist may be limited in the duties performed, and they may be, limited in their knowledge about those complex laws that govern special education, which is critical for an LEP in independent practice. So like I said, but some may choose to employ a credentialed school psychologist and be performing that full range of duties. So it would be reasonable to allow experience in these settings if it's comparable to the duties performed in a public school. The proposed language would require certification from the supervisor or other authorized representative from the school, stating under penalty of perjury that the applicant performed the full range of duties as a school psychologist as set forth by the Commission on Teacher Credentialing. I've listed those authorized duties here in the memo. So again, they would have to just certify that they perform that full range for that experience to qualify. There's kind of a similar issue, not exactly the same, but for experience gained while employed in a temporary employment agency. This is happening more often because there are some shortages of school psychologists. So schools often bring someone in under a temporary contract. Sometimes they're full-time though, and maybe lead to the person being hired on by the school permanently, but sometimes they are limited term just for the purpose of helping with student assessments. Again, Chris, thank you for explaining a lot of that to me. There's a lot of technicalities to how things are working in the schools. So, but sometimes, like I said, they are covering that full range of duties. So similar to that proposed requirement for private and parochial schools, it would just require that certification that they perform the full range of duties of a school psychologist. The next thing would be to specify the documentation of experience required to be submitted by applicants. So just laying out the minimum necessary documentation to verify those experience requirements, just to make sure that we can ensure they meet the specifications in law and just ensure that accuracy of the information provided to the board. Then for that 1 year of experience gained under the direction of an LEP, the proposal would define what under the direction of means. Right now, it's just that's all it says, under the direction of an LEP. So we would define that as meaning that the applicant was under the licensee's supervision, and then we provide a definition of what supervision means, just a simple definition. Since right now you can interpret that differently. So, and then we would also add that the supervisor needs to hold a current, active, and unrestricted California LEP license while the experience was gained. and it would prohibit the supervisor from having a financial, personal, business, or therapeutic relationship with the supervisee to prevent bias in the supervision process. Lastly, we added a section that would require the supervisor to be competent in the areas of practice and techniques being supervised, and also includes a definition of what we mean by competent to ensure only qualified supervision occurs. So recommendation is to conduct an open discussion regarding the proposed amendments. And after review, we have potential motions. So I'll open it up for discussion.
Thank you, Christy. Thank you for all the hard work that you've done on this. I know it's been quite the task. So do we have any comments or questions from our committee members? John.
Just a quick question. Under the competency for a supervisor, and Chris, like you may be able to answer this directly, is there actually like a supervision training that LEPs are required to take before they supervise?
No. Well,
yeah, they would have to take.
It depends who. If they're supervising for so LEPs can supervise for the other professions, LMFT, LPCC, and LCSW. But it's very different for a school psychologist in a school setting. There's the structure of the school, so they're already working in that school setting, and so there is that sort of framework already in place. But Chris, I don't know if you want to elaborate on that, but right now we don't require supervision training for supervisors to supervise a credentialed school psychologist.
Or the general rule that we have within the profession is that if we're supervising the equivalent of like a grad level intern, is that you have to have worked for 2 years as a school psychologist before you're allowed to sign off on hours. And then they have domains that they need to follow, and then we have to go through checklists with the university to make sure that we're hitting all of those responsibilities. But there's not like a certification like you have to do for the other licenses, because it's not the same kind of clinical model. It's close, but it's not quite the same. So with regards to supervision of a credentialed school psychologist who is in the process of wanting to get their LEP, that year of under the direction of like Christy said has been pretty amorphous. But the intent at this point is to be under the I'll even call it indirect supervision. So the thought is that the LEP who is supervising the person trying to sit for the exam will go through the different domains of what they're supposed to do within a private practice setting to help prepare them for both the exam and then working within a private practice setting if that's what they choose to do. There's a lot of LEPs that don't actively use their license outside of the school district, or they do on a very limited basis. So I don't know if that helps John or not, or if I just was rambling. But
so Christy, may I ask you a question?
Sure.
So considering we're so close to getting all of this stuff implemented already, would the idea of looking at regs for supervision, bringing them more equivalent to some of the other licenses, be something maybe to revisit at a later time rather than trying to add into this package currently?
Good question. I don't know, what are your thoughts, Roseanne?
I think I agree with that. I think that it's the
LEPs look drastically different, and we kind of want to walk the line of balancing what they're already doing and their experience, because there's a lot of different experience to be an LEP. You already have to be have been a school psychologist. You have to have all this other experience. Whereas an associate, you're kind of coming in just from out of school green. So we needed to kind of balance, and we need to weigh carefully the need for extra coursework and things like that with the willingness of people to want to do that in order to supervise LEPs. If that, we don't want to overburden, since and it's a little bit of a different situation. So I think we need to look at that carefully.
So taking that in mind and considering, public safety is, one of our keys, and we're looking to help create the best people moving out into the field, then maybe, Christy, we can make a note to visit this later on to look at, because over the last few years, we've got a lot of tightening up, especially of the LMFT supervision models. With, the 2-year thing, must be seeing, a certain number of clients, having to take the coursework, stay up to date, having the paperwork. There's been a lot of work to really, really tighten up the supervision model for LMFTs in the pursuit of having the best supervision possible, which then will help us to produce the best therapists possible, hopefully. So maybe we notate to visit this later, because I do want to make sure all of this stuff gets through, since we're right in the middle of everything kind of on the cusp. Does that make sense?
Yeah, absolutely.
Okay.
And John, remember too that that when somebody sits for an LEP exam, they've had to already work as a professional for at least 2 years. So they've already done their their internship hours under supervision, and the year of supervision under an LEP is an and or. So if the way the statute reads now is that you can use your supervision year when you were under direct supervision as a grad student, as opposed to a year under an LEP, unless you're coming from all of your experiences coming from out of state. That was an additional change that we recommended, because California is so unique to the other states, and although the practice of school psychology is similar across states, we all know it's very different here. So that was one of the stipulations that we wanted to change in order to in order to help to ensure public safety. So the by the time someone's ready to sit for their LEP, they've already been working at least minimum of 2 years as a fully credentialed school psychologist. So they've done. You look at, I mean, that's where we came up with the 3 years, because it's equivalent to about 3,600 hours of practice time by the time they're even allowed to sit for the exam.
Mm-hmm. And so, yeah, I would just like us to keep this for future thought, as once again a way to help supervisors be the best qualified supervisors, and for the people receiving supervision to make sure they're receiving quality supervision. So just kind of notating this as potentially some future language to talk about.
And John, I'll add to that. I think it's in the next meeting later today in Workforce, we'll be talking about some survey results where there's some discussion about strengthening supervision that sort of arises for all of the license types. And so I think that there will be an opportunity fairly soon on the horizon to circle back and look at this for all of the license types, including LEPs.
Perfect. Thank you, Roseanne. Any other comments from our committee members? No? Okay.
I did have one comment, John. This is Chair Jones. This is Christy Shield, Regulations Counsel for the Board. I did want to just highlight that one of the policy objectives of this proposal is to increase pathways to licensure for licensed educational psychologists. So the statutes would be amended currently at 4989.20 of the Business and Professions Code. It says that the experience would be gained as a licensed or credentialed school psychologist in the public schools or equivalent, but we are amending to say or in another school setting. So we're opening up the opportunities for licensure, and the regulations reflect those different settings that we were talking about at prior meetings. And also it resolves a lot of the ambiguity that's currently in the statute about what you consider equivalent, which has been a challenge for your staff when processing applications. So the goal would be to allow more pathways to licensure and also make it easier for staff to process applications, making licensure, potentially quicker with these amendments in statute and regulation. So I just wanted to highlight that, that the policy goal is really to open up these pathways, make it easier to get licensed for this profession. Thank you.
All right, thank you. If there's no other comments from our committee members, I'd like to make a motion. Chrissy, can you help me with this? I think I know I'm supposed to say, but I want to make sure that you're right.
I can read it if you like.
Please, that'd be great.
Are you assuming you're going with no changes requested to the text, correct? Okay, so motion
That is
A.
correct. Yes.
So that would be recommend to the board approval of the proposed regulatory text in attachment A, and recommend the board consider all of the following actions. After enactment of SB 775, direct staff to submit the text in attachment A to the director of the Department of Consumer Affairs and the Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing if requested. If no adverse comments are received during the 45-day comment period and no hearing is requested, authorize the executive officer to take all steps necessary to complete the rulemaking and adopt the proposed regulations as noticed for Title 16 California Code of Regulations, Section 1856.
Thank you. I will make that motion. Do I have a second?
I'll second.
Thank you. Any further comments from our committee? Any comments from Shanti?
No comments.
No comment.
All right. Are there any comments from our remote participants, moderator?
This is the moderator. If you'd like to make a comment, you may look for the hand icon and click that to raise your hand. And our call-in users may press *3 to raise their hand. Are there any comments on the motion or the issue? I do not see any requests for comment. I will turn the meeting back to you, Chair Jones.
Thank you. All right. Christina, would you please take the vote?
Chris Jones,
Yes.
Kelly Ronasinghe,
Yes.
Wendy Strack,
Yes.
John Sovek.
Yes.
Motion carries.
All right. Thank you. Next on the agenda is the discussion and possible recommendations regarding restructuring the pathway to licensure for licensed marriage and family therapists, licensed clinical social workers, and licensed professional clinical counselors. Roseanne, would you provide us with an overview?
Yes, so at previous meetings, the Workforce Development Committee has been considering several potential modifications to our licensing pathway and process aimed at reducing barriers to licensure. Our licensing and exam statutes are really complex and they vary from license type to license type. So we need to be really careful about making any amendments to prevent unintended consequences and affecting people that are already in the licensing process adversely while still moving forward and making changes that would be helpful. So we've been really weighing carefully some of these changes and the effects they might have and the costs versus benefits. And so we've come up with a phased approach to implementing changes because they need to be implemented carefully because there's so many moving parts and people in various parts of the process. So the proposal involves 3 different steps. So phase 1 involves amendments to the licensing and examination framework, and they're going to be discussed today. And these are things that can be implemented fairly easily. They don't have a lot of adverse effects to anybody. They don't require a whole lot of behind the scenes changes to our data systems and things like that. Phase 2, which we're working on in tandem at the same time, is we're working to transition towards the Association of Marital and Family Therapy Regulatory Boards, that's the AMFT-RB national exam, as the clinical exam for LMFTs. And that's going to involve a pretty significant shift for applicants already in the exam process. There will be some significant database modifications that will need to happen, and a whole transition process there. So the board is in the process of discussing that and making sure that things that need to happen in order for that to go smoothly and be effective actually happens. We're in the process of doing that. And then phase 3 would be kind of the final like cherry on top. So phase 3, we would like to propose adjusting the timing of the board's clinical exams to allow candidates to take those exams earlier in the licensing process. And that's really a big, important final step, but it's also complicated. It requires buy-in from the national examinations, so that they're going to allow us to do this, first of all. And then we have a lot of people that we have to sort of change the structure of when that shift is going to take place and how it's going to affect people that are already in the exam process when we make those changes. Because if we're not careful, there's a potential for some adverse impacts to people if we sort of change the game for them midway, and we don't want to do that. So a summary of the proposed phases is provided in attachments A, D, and C. We have kind of a visual summary and description of each phase, estimated timelines, and then what the end result licensing process looks like with all of these 3 phases if they were to get implemented. So, but that's kind of where we're going big picture. Today's discussion, we're just discussing the phase 1 changes, and those are shown in attachments A1 through A4 for each license type. The goal is if everybody likes the changes and is on board with them, the goal is to have these be approved by the board to run as a legislative proposal in the next legislative cycle, which begins in January of 2026. So I'm going to discuss the proposed phase 1 changes for LMFT, LCSW, and LPCC together first, and then I'm going to discuss LEP separately because their licensing process looks a little different. So for LMFT, LCSW, and LPCC Practice Acts, we've drafted the language for each one of those. It's shown in the attachments, and that makes several different fairly significant changes. We are proposing to change the timing of when the California Law and Ethics exam is taken. It would basically allow associates to choose when they take the California Law and Ethics exam instead of requiring them to attempt it each year until the exam is passed before they renew. And this is where a lot of people get into trouble and don't realize if they forgot to take the exam and then their license comes up for renewal, but they didn't take the exam. Now they're in danger of it affecting their job because they have to take the exam to renew. And so under the new proposal, associates would just instead take the exam when they feel ready. If they feel ready that first year, great. If they want to wait till the second year, that's fine too. The only requirement is that they have to take their exam before they obviously apply for the clinical exam eligibility, which is final licensure when hours are gained. And also if they need a subsequent registration number 6 years down the road, they need to have passed it to get that. But otherwise, they can just choose when they take the California Law and Ethics exam. It was originally required to be taken every year because we wanted licensees to be considering law and ethics when they're practicing as registrants, to be taking training in it if they can't pass the LME exam. But a couple of years ago, actually in 2023, we implemented a new requirement that associates now need to take a 3-hour continuing education course covering law and ethics every year. So staff believes that maintains public protection in lieu of requiring that exam be attempted. So that's the LME exam. Another thing that we're proposing to do in this proposal is put an age limit in for the California Law and Ethics exam. That is something that is needed as part of the exam structure. We did not put an age limit on, and now we're realizing that we need it as time goes on. The California Law and Ethics exam has been offered since 2016. And the board currently must accept all scores regardless of age. However, seeing now that that exam has been in place a while, some of those scores are getting older and older, which raises the question of if somebody passed an exam in 2016 and let's say it's now 2035, is that score really still acceptable, or do they need to demonstrate some kind of current knowledge of California law and ethics? So what we are proposing is a 7-year age limit. To obtain a subsequent registration number, the applicant will need to have passed the law and ethics exam no more than 7 years prior. In addition, when applying for initial license issuance, the California law and ethics exam needs to be no more than 7 years old. And so this is one of these things where we have to be careful about implementation and adverse consequences to people that are already in the process. So recognizing that when this law takes effect, potentially in January 2027, there might be people that their score is just becoming 7 years old and are about to apply for a license and they're not aware of this. The proposal has written into it a 3-year grace period from the anticipated effective date of this bill. So during this grace period until January 1, 2030, we would not enforce the 7-year limit on the law and ethics exam to give those individuals who are not expecting that to happen time to prepare and be aware of it. So the next change that we are proposing in this proposal is to change the registration number, length, and time supervised experience hours are valid, both from 6 years to 7 years. Right now, a registration is valid for 6 years, and at that time, they need to obtain a subsequent registration number. And that's significant because with a subsequent number, you can't work in a private practice or a professional corporation. Additionally, right now, experience hours are required to be no more than 6 years old, and they expire incrementally as they become 6 years old. We're proposing to make that, to allow them to become up to 7 years old. Extending these timeframes allows applicants an additional year. We hear a lot of times people have concern because they need to take a break, they have life circumstances happen or a hardship, and they want to take a break from the licensure process if they have to worry about their hours expiring. So this will give them a little bit more breathing room. It also aligns the allowable age of experience hours with the clinical exam score and the allowable law and ethics exam score. We're changing that to 7 years. So you'll kind of see there's an alignment where everything will be 7 years. And that sort of sets the stage for what we want to do eventually in phase 3, which is rather than what we're doing now with locking hours in the exam cycle and things like that, we're going to end up eventually requiring everything to be 7 years. And aligning everything at 7 years makes it sort of easier to remember than if you have all these different age requirements. This one's 6 years, this one's 5 years, 7 years. It's just everything's 7 years. It's simple and easy to remember. So that's what we're attempting to do there. The next thing is, I mentioned a second ago that if you need a subsequent registration number, you are not allowed to work in a private practice or professional corporation. That creates a hardship for certain individuals. Let's say they need a subsequent registration because they got a first registration and many years went by and now they need a subsequent, and they're told, well, you can have a subsequent, but even though you never used your number, you can't work in a private practice to gain your hours. Or they have a job in a private practice with their first number, now they need a subsequent and they realize they need to find new employment because they're not allowed to work in a private practice. Maybe they can't find a job anywhere else. So there's several different hardships, and we've heard this again and again over the years that this really creates a hardship for people. We've discussed it at the board level numerous times throughout my tenure here. The most recent time we discussed it was in August 2022 at the board meeting. There was not really an appetite for removing that prohibition because there's public protection concerns about potential exploitation of associates. So there was not really support from the board or its stakeholders for removal. So what we're proposing today is a more limited approach that would apply for a limited time in instances of hardship. And what we're proposing to do is we would continue to generally prohibit associates from working with a subsequent number in private practice. But we would permit an associate with a subsequent registration number to request a one-time 2 consecutive year hardship extension. And so they can finish gaining their hours working for one private practice or professional corporation if the supervisor or employer and the associate all submit a signed request to the board specifying information and showing good cause. And we're not going to be really hard on what the good cause is. We give some examples. We just want that person to really think about, hey, this is my sort of last chance to work in this setting. It's a one-time only thing. We don't want it to be, because we don't want it to be exploited by companies or anything like that. But we do want to give those people a chance to finish their hours, and 2 years is sort of the minimum time that it takes to finish hours if you have none. So that's kind of the goal of that piece of the proposal. Okay, other things this proposal does, there's a lot of technical changes. We are deleting the requirement that if an applicant is unable to pass the clinical exam within 7 years of their initial attempt, then they must go back and pass the California Law and Ethics exam. We believe that placing an age limit on the California Law and Ethics exam and requiring everything to be 7 years old is going to render that requirement obsolete. We're making amendments that clarify that the board may accept a passing clinical exam score obtained early in another state. Our board doesn't grant eligibility until all education experience is gained, but some states allow somebody to take it early, maybe right after school, especially LPCCs. And so there's kind of a question in the law. The law's not really clear about what to do with those exam scores. Do we make them go back and take it again because they weren't technically eligible under our standards, or do we just allow that score? So this would allow it as long as it's not 7 years old or older. And there's a few other things that I've sort of summarized in the packet that you can take a look at. That's the first 3 license types. So after we did all of that, we went and looked at LEPs. And LEPs are quite different for a number of reasons. They take a single licensing exam, so they don't have a law and ethics exam that's separate. Theirs is all combined into one exam. They are not required to register with the board as an associate to accrue supervised experience hours prior to licensure. So their licensing law looks very different, and a lot of these proposed changes don't apply. However, the one thing that does apply is that LEPs are currently subject to a 6-year time limit on their qualifying experience hours. So we recommend extending the 6-year allowance of age of experience to 7 years for LEPs as well. So you'll see that change made for them, and then a technical amendment about the deleting an outdated exam rescoring fee. But you will notice that the LEP language looks a lot lighter than the others, and that's because they're just things apply differently. It also, the language shown in attachment A4 assumes amendments to that particular section for LEPs 4989.20. Those are currently running in SB 775, so it assumes that those amendments become law on January 1st, 2025, which we believe they will. If all of this is successfully adopted, we will need to have corresponding regulatory changes and regulatory cleanup in our statute, in our regulations to ensure consistency with statutes. So just know that work is coming too. So you'll be seeing something about that if it looks like this is going to go through. This has been discussed a long time in our Workforce Development Committee. At the last meeting in April, they directed us to draft the language for all license types and bring it to the Policy and Advocacy Committee. So the recommendation for today would be to conduct an open discussion about the proposed amendments. Oh, and also I need to mention one more thing. There is a suggested amendment to 4984.01E, 4996.2AD, and 4999.100E. We would include in the temporary or the prohibition on private practice one-time 2-year exemption. It says the applicant may request that the board grant them a 2-year consecutive hardship extension. Can't ask for a clarifying amendment there to call it a one-time 2-year consecutive hardship extension, just for clarity. So that is part of the proposal too, even though it's not in your packet. So I'll open it up for comments, questions, discussion.
Thank you, Roseanne. That was great. Are there any comments from our committee? Oh, is my mic not working?
There, that's good.
There. Sorry. Thank you, Roseanne. That was great. Are there any comments from our committee members? John.
Hey, Roseanne, in that same subdivision you were just looking at in E, under 3, this is about the extension piece. It says work for the employer shall not commence until the extension is approved by the board. Does that language cover the space of people who are already working there? Because commence to me means begin, but if we have people who've been working for this organization, is it commence and continue?
It's commence and continue. So they would need to apply for their subsequent registration number, and then they would need to wait till we approved it to begin work.
I think
Maybe we should say continue?
yeah,
Or
because they can apply for this while they're still in their first registration, right?
And we left it at it has to be approved by the board because we want to leave it so they can either specify a date, like maybe they're being really proactive and they see that in 6 months this is going to happen and they apply now. So we want them to either be able to specify, oh, I want this when my subsequent registration number goes into effect, or maybe somebody is already worked, has the subsequent number and they want it by a certain date because that's when their job is starting. They don't want us to approve it too early to start their 2-year clock. So we want to kind of leave it up to them, but maybe we should say shall not commence or continue.
Yeah, because once again, looking at timing, let's say my thing expired tomorrow, August 1st, and my approval hadn't come through. Am I not allowed to work next week to gain hours of experience?
That's correct, you're not.
So that's harm to clients.
It's not going to be it's kind of like the subsequent number, like we want them to basically, if they're doing that, apply at the same time. So they have to think ahead, I'm going to need a subsequent number, I need to apply to the board. We're planning on doing this somewhat like the temporary practice allowance, where it's a pretty immediate turnaround. We're kind of envisioning it be something that's done online and sort of walks you through the process. So it's for the temporary practice allowance, they get an email basically immediately or by the next day. This is going to require a little bit more human review, we think, but we don't expect it to be like licensing processing timelines at all.
And this will give us that, because what we're trying to do is usually, like Roseanne was talking about before, we have individuals who forget that they have to apply for a subsequent number, and it causes complication because it can take an extended period of time. So for continuity of care, this would, if they recognize, that week that they had to apply for their subsequent, this could be a quicker turnaround. But still, I think we have to have that where they wouldn't be able to continue that work necessarily until we approve that. So there could be a gap, but it does give another option to, decrease that risk of having that continuity of care be,
There could be a gap, but it's better than it is now, where it's if they find out that they didn't know, then they're done at that site. There could be something like a week delay if they are not proactive and don't realize it, but it probably wouldn't be a very long process because the process to do this would be very involved and labor intensive.
And also it gives the employer confidence too, because I think when the employers right now with the subsequent I think that kind of gets them, it's like, oh, there is a solution that they can help with. I don't know how to explain it, but I think it gives them more confidence that, oh, this is what we can do right now. Let's get you moving forward. I think it's definitely better than what we've experienced and have. It definitely fixes a problem.
So I think the thing that for me, it's more accurate to say continue than commence.
I have a thought. I think really what this is intended for is people who hold subsequent registration shall not begin working. So I think maybe we need to call out an individual who holds a subsequent registration shall not commence working for that employer until the extension is approved. That's my thought, because if you're already in your if you're still in your first registration, you're obviously working for them right now. So that doesn't really apply.
So under E, should be continue then with that thought process.
Well, not necessarily, because they might be, maybe they found a new job in a private practice, and now they're going to start that new job. That the only place that would hire them is a private practice, and so I would think that it should say maybe commence or continue.
Okay.
Work for the employer with a subsequent registration number. Or how about once a subsequent number is obtained?
Work can commence.
Think here. Once a subsequent registration number is obtained, comma, work for the employer shall not commence or continue until the extension is approved by the board. What about that?
I think the once part maybe doesn't quite work. Okay. I think it should be something like an individual working under an individual who has a subsequent registration number shall not, because once they've obtained it.
This is Sabina. Aren't some people with a subsequent registration number already employed, and then they just need to get this? It's not like they're going to start a new employment, right?
They could. They may.
They could.
Yeah.
Right. But not necessarily. They might just want to be continuing, right?
Yeah.
The other thing too is it's an exempt setting.
I think that's why I lean towards Roseanne's commence and continue. I think that covers the basis.
That seems to be the logical thing, because then you either have shall not commence or continue.
Can you repeat that again? What were you thinking?
Shall not commence or continue until.
An individual with a subsequent registration number shall not commence or continue
work under the employer.
Continue practice.
Continue work in a private practice. Commence or continue work in a private practice or professional corporation.
Yep.
I think it's very simple.
Okay, let me read this again and see what you think. An individual with a subsequent registration number shall not commence or continue work in a private practice or professional corporation until the extension is approved by the board.
And just to keep your language consistent, you've been using professional corporation employer above.
Yeah.
Continue work for a, good point, private practice or professional corporation employer. An individual with a subsequent registration number shall not commence or continue work for a private practice or professional corporation employer until the extension is approved by the board.
I love to speak.
Can we take a public comment here?
Well, it's not totally public comment, but it's interesting. I don't even know if you necessarily need to have like that very beginning part about the person, because 3 stems from E, so you kind of already identify the applicant and everything. So I don't think it would be a little redundant, I guess, if you say like a person who already has one, and if you do that, it kind of goes against E above, which also has the applying for.
Mm-hmm. Oh, yeah, that's true. It does say one private practice or professional corporation. So maybe it just needs to set the amendment is just commence or continue.
Commence or continue.
How do we feel about that? After all that, okay, let me erase all of the things so I don't get confused when I look back at this. Okay. So work for the employer shall not commence or continue until the extension is approved by the board. That's what's on the table. Are we happy with that? Okay.
Thank you, Shanti.
Sometimes we need somebody to see the board.
Right? Is that the original already?
No.
No.
Yeah,
So basically after commence, we're adding or continue.
What number is it?
It is 4984.01E 3 and also 4996.28D and 4999.100E. You need me to say that again?
What attachment?
A1, A2, and A3. All right. Do we want to move on to other comments?
All set.
Oh, can't hear you. Sorry. I think you're muted, actually.
Yeah, I think he is.
There you go.
Okay. One of these days, I'm going to figure out how to work Zoom. You have all the language you need, Roseanne?
Yeah, I think we have everything we need for that. So yeah, we can, I think we can probably continue on the discussion. I'm sure there's probably more things people want to discuss. So.
Perfect. Any more comments from our committee? Anyone want to make a motion?
Do you want me to read what the motion should be?
Oh, yes.
Yes.
Because we're not looking at, you're just looking at making the non-substantive changes, correct?
Not necessarily, no. So the motion would be to direct staff to make to make the discussed changes, which are amendments to 4984.01, 4996.28, and 4999.100, adding one time to the discussed sentence in those sections, and also adding the change to all three that work for the employer shall not commence or continue. So we need to direct staff to make those changes, any non-substantive changes to the language, and then to bring to the board for consideration as a legislative proposal.
Do I have a motion?
I so move.
Mm-hmm.
Thank you, John. With a second. All right, I'll second. Any further comments from our committee? Any comments from Shanti?
Yes, thank you. So Shanti Ezra with CAMP. Really want to thank you, Roseanne, for your work on this. Incredible overview, a lot of work on the statutory changes. Wanted to share that we continue to be in support of the changes to the licensing process, and we've also had a chance to review the proposed statutory language, and overall I think it looks really good. Just a couple comments that we've already actually shared with you via email, but I just want to voice them here today. So first, starting with the Business and Professions Code section 4984.01, the one that you had just covered on the 2-year hardship extension. Thank you for adding into, I think it was subsection E, the one time to the hardship extension language. A couple of new comments though that we haven't already talked about today. So under the same subsection E under 5A, we do think additional language that offers the applicant options to select the commencement of the 2-year span would be helpful. The reasoning behind this is really to take into consideration those individuals who are proactive in requesting an extension, as well as those who might need the extension as soon as possible. And then the second comment that I have is related to one of the minor technical cleanup amendments that allows the board to accept a passing clinical score from another state. We've noticed the few subtle changes in the language and understand that the law doesn't preclude the BBS from accepting a clinical score from another state. Since you've already shared that corresponding regulatory changes will be required to ensure consistency with statute, we think it'd be a great idea to also include language in the regulations that explicitly clarifies that point. And then I'll hold off, but we do have some few other questions related to implementation that we'll just continue to work with you and the rest of staff on as this moves forward.
All right. Thank you, Shanti. Are there any comments from our remote participants?
This is the moderator. We do already have a raised hand, but for everyone else, instructions are on the screen. If you'd like to make a comment on the issue, you may look for the hand icon and click that to raise your hand. Each speaker will have 3 minutes with a 15-second warning, and our call-in users may press *3 to raise their hand. Our first comment is from Ben Caldwell. Ben, I'm going to send you a request to unmute your mic.
Good morning. Can you all hear me?
Yes.
Great. Thank you. Good morning. Ben Caldwell, MFT. Echoing Shanti, Roseanne, I want to thank you again for your continued work on this. I always really appreciate your explanations because you take this really complex process and make it a lot clearer. So thank you for that. And I encourage the committee to move this forward to the full board. I just have one question. It's technical. I don't want to slow down the process here. It might just be something to kind of take under advisement as this does move forward. You're proposing removing the requirement that people retake the law and ethics exam if they haven't passed the clinical exam within 7 years of their initial attempt. And my understanding from reading this language is that that provision would kick in right away when the legislation takes effect. But the broader 7-year age limit for the law and ethics exam wouldn't kick in until 2030. And so I'm just wondering, is it possible for someone to sort of slip through in the interim? Would it make more sense to align the implementation of those two provisions just for sort of clarity and consistency so that people get the message that your law and ethics exam is basically good for up to 7 years? I can't imagine this would impact more than a handful of folks. That's why I don't think it's a significant issue, but just something for consideration. Thank you again.
Thank you, Ben.
I've thought of that too. My take on it is that when we eventually switched, we only accept the clinical exam for 7 years. So if they have a score for that's more than 7 years old, it's not going to be accepted. For the L&E, we're putting in that 7-year requirement. If for some reason somebody continues to take the clinical exam past 2030, eventually it's going to catch up with them anyways. And when we let people start taking the clinical exam and the L&E exam independently of each other, which is the proposal for phase 3, they would just be able to take it anyway. So I don't know that we really had the concern that there's a harm in continuing to take the clinical exam indefinitely, because eventually the L&E is going to have to be passed within 7 years. So if a few people after, like in 2030, have an old score and continue to have an old L&E score and don't apply for licensure successfully by 2030, eventually when they apply for a licensure, they're going to get caught in that anyways. Mm-hmm. That's how I sort of see it. Steve, do you agree with that?
Yeah, no, that's definitely.
So I sort of feel like the confusion in trying to align that sort of outweighs the benefit of what we're trying to do.
Once again, it's a very small percentage of people that will be.
Because they are still they're either going to have to become licensed by 2030 to avoid that, or in 2031, if they apply, we're going to say, well, you have an old score. So.
Thank you, Evan. Any further comments from our remote participants?
Yes, we do have a comment from Bindu Mukamala. I'm going to send you a request to unmute, and you'll have 3 minutes. And you're unmuted. Go ahead. And Bindu, we're not hearing your voice. And with the drop down that's next to the mute and unmute button, you may be able to choose a different microphone. Okay, we're still not hearing you, so I'm going to go ahead and open up the chat feature if you'd like to go ahead and include your comments in the chat. You now should see a little speech bubble at this bottom row that says chat. And if you could just type yes into that chat if you can access it so we know. Okay, no problem. Go ahead and just type your comment. And I'm going to give you 3 minutes to type. All right, so Bindu's comment, very quickly, we, the NASW-CA, wanted to request if the board would consider offering a 30-day waiver for applicants that are receiving an extension for the subsequent registration number. And so at that point, I do not see any further. Oh, Dr. Jasmine Smith has a raised hand. Dr. Smith, I'm going to send you a request to unmute. Go ahead. Yes, go ahead. Oh, goodness, Dr. Smith, I'm having a problem hearing you as well.
Can you hear me?
There we go. Yes.
Okay, sorry about that. So just to provide some clarity, because I know Bindu was having some issues with her mic, the discussion about the commencing and continuing, and I don't recall the individual's name, but the question about harm to clients, right? So if someone is applying for that subsequent registration number, and I know the ideal is for the process of review to be quick, but if it's not quick, that could have an impact to the clients, especially if that provider is working with someone that may be high risk. So just in the thought process of what that disruption could potentially look like, wondering if it could be similar to providers who are out of the state of California, but have a client that is here, maybe relocating, and then they get that 30-day waiver to be able to work with that person in the interim of either deciding to try to get that license or to provide referrals that could be in California to support that person in that transition. That was one of the comments. And I believe the second comment that Bindu wanted to share briefly was wanting to just elevate questions and support around potential hours during social workers internship that could support towards their licensure hours. As you know, we have to accumulate the 3,000 and wondering if we can get support in mirroring some of that work similar to MFTs that can count their pre-degree hours towards their licensure hours.
Thank you. And I do not see any further requests for comment. Shall I close the public comment feature?
Yes, thank you.
You're welcome.
Any further comments from the committee or Roseanne? Okay. Christine, oh, go ahead.
Wait. Okay, so we have a few different suggestions on the table. The possibility to select the beginning of the 2-year span from camped. I would say that staff can work more with them offline between now and the board meeting to look at what that language would look like. We're not sure right now that it's necessary because it already says the commencement, but we'll get more clarity on that. In terms of the removing the L&E is not passed within 7 years. We don't think that change is necessary, but if the committee does, or Steve and I will talk about it internally, we'll run through that one more time, but we don't think that scenario is particularly concerning. The 30-day waiver for the subsequent registration number, I'd be interested to hear the committee's thoughts on that. My concern is that it's sort of adding another level of confusion. So it's you're applying and you have a 30-day, much like the 90-day rule. Right now, we're not allowing people, if you need a subsequent registration number, you're done. You're done. You can't see your clients anymore. So this is allowing a chance, and they already have to think ahead to apply for the subsequent registration number, which is going to take longer probably. Yeah. Is that an accurate statement than doing this request? So it's probably something that they can do at the same time. Or they can request if they're in the process of getting a job, they got a job at a private practice and they know their start date, they can submit that right away. So we think there's going to be already pretty much a level of awareness, and if it's a quick start date, it's going to be fairly quick for them to start. So not sure that it's worth adding that extra layer of you get your 2 years and then you get 30 days. Just knowing how much confusion we sort of have already around the 90-day rule.
Definitely.
But it's definitely something for the future if we see a lot of hardship with the processing time once we implement, which we don't think will happen. It's definitely something that we can revisit on how to do a fix. So that's my sort of take on that. In terms of Jasmine's comment about the potential hours during internship to count for ASWs, yes, that is definitely something we're looking at. We're going to be talking about that in the Workforce Development Committee in future upcoming meetings, both for LPCC and LCSWs. We're not quite there yet, so it doesn't belong in this proposal yet, but that discussion is forthcoming for sure.
I want to just make one comment about the 30-day waiver. That another reason I don't think it's necessary is because in the application for a subsequent registration, we're going to put that information in there about, because it already says in that application packet you cannot work in a private practice or with a subsequent registration or professional corporation. We're going to add in, however, if you can apply for a one-time extension, apply now if you need it. They can submit it with that application. And again, there is a processing time for that application, so the two can be approved together.
And in terms of like the start date, if somebody needs the start date, the plan is sort of an implementation. I think, and correct me if I'm wrong. Either they can specify a start date, or they can choose upon approval, because maybe they don't want it to start until their subsequent registration number clock starts. You don't want those timings. So we want to figure out a way to time those together so that the person can sort of pick whether they're starting a job and they need it ASAP upon approval, or hey, I want this to go with my subsequent registration number effective date. That will matter for them. So we don't want to write anything in that's limiting. So that's kind of the thoughts on the comments.
Thank you. Okay, if there's no further comments, then Christine, would you take a vote?
Chris Jones,
Yes.
Kelly Ramasinghe,
Yes.
Wendy Strack,
Yes.
John Sovek,
Yes.
motion carries.
All right, thank you. Let's take a quick break. We've been almost an hour and a half. So let's come back in 10 minutes.
15,
Thank you.
maybe? Steve.
Oh.
Solid. Just let him remind us.
I think we're all here, ready to go.
Ready to go? All right, perfect. Thank you. Welcome back from the break. Next on the agenda is the discussion and possible recommendation regarding statutory amendments related to the practice of pastoral counseling. Sarita, would you provide us with an overview, please?
Hi, you could hear me okay, right? Okay, just trying to project as much as I can because sometimes my voice drips off. So, the board's practice acts require valid and active license or registration to provide services within the scope of marriage and family therapy, clinical social work, professional clinical counseling, and educational psychology. The business and professions codes outlined in this memo 4980.01, 499.22C, and 4996.13F currently exempt priests, rabbis, and ministers of the gospel of any religious denomination when performing counseling services as part of their pastoral or professional duties. The board notes the benefits to pastoral counseling for those seeking guidance for personal matters, but there are also concerns when an unlicensed individual appearing to be working in their ministerial or pastoral capacity incorporates practice methods into their counseling that are to be utilized by a licensed mental health professional. The board has occasionally received consumer complaints of this nature where it's noted the individual claiming to be performing in the ministerial or pastoral capacity is providing counseling services independently outside of a religious organization, and the individual will charge a fee for services that are separate from the compensation received for their customary duties of a religious organization. Due to the language in our current exemption statutes, sometimes the board is unable to take any disciplinary action. Just a little bit of a background of when the discussion started. The topic was first discussed at the former licensing committee meeting in January of 2023. At that meeting, it was proposed to clarify the exemption language in the board's practice acts, but the intent is not to regulate individuals performing in a pastoral or faith-based capacity. And at that meeting in January 2023, staff provided examples of exemption language that provides more clarity for individuals performing in a faith-based capacity, which can be found in attachment B. Since that meeting, staff collaborated with subject matter consultants to conduct further research, and the articles and publications that were retrieved are also outlined in the memo. In addition to reviewing publications to distinguish the difference between pastoral and clinical mental health counseling, we also considered the diverse religious and cultural influences in regions throughout the United States. So staff and subject matter consultants also researched and reviewed additional exemption language in other states, just to kind of get some guidance and examples, which are shown in attachment C. And those research findings were presented at the previous policy meeting back in January of this year. Following that meeting, staff began the process of drafting amendments to the language using Business and Professions Code Section 4996.13 for the LCSW Practice Act as the foundational model, because the language compared to the other practice acts is more comprehensive and detailed in that Business and Professions Code section. And after consulting with subject matter consultants and legal counsel, it was determined that the proposed amendments to the language should focus on faith-based counseling rather than pastoral counseling. Additionally, the language should establish clear criteria distinguishing faith-based counseling from clinical mental health counseling. So the aim of the proposed amendments is to provide these following differentiation factors for individuals performing in such capacity, in a faith-based capacity. The service and activities performed are under the direct auspices of the faith-based entity, such as a church, synagogue, mosque, or other recognized religious organization. Fees beyond the religious officials' customary compensation from that faith-based entity are not charged or received. The individual does not state or imply they are licensed or registered to practice clinical social work. This is in the context of the LCSW Practice Act. and they do not hold themselves out to the public by any title or description of services incorporating the word psychosocial or clinical social worker. And lastly, the services provided by the individual are limited to counseling services in a religious or spiritual context and do not involve the diagnosis or treatment of mental health disorders. The amendments were also drafted for the LMFT and LPCC practice acts. At this time, it was determined not to draft amendments to the language for LEP practice due to the differing nature of the work in LEP profession. Those can be found, the amended language can be found in attachments A1 through A3. So we recommend conducting an open discussion of the proposed amendments found in those attachments for the LCSW, LMFT, and LPCC practice acts. In addition to our discussion, we also wanted to address the LEP and nursing practice acts and discuss whether to include mention of those practice acts in subsection A of the proposed amendments and those for the 3 license types that we drafted the language for. In addition, also the duty types, given the similar meanings for pastoral and professional duties, this is within the context of the proposed amendments. Discuss whether to include both duty types. So there's a portion in the language where it says regular, pastoral, or professional duties, whether to keep both terms or amend the language only to pastoral as a duty type. And then we just also recommend to direct staff to make any discussed changes and any non-substantive changes and bring to the board for further discussion.
All right, thank you. Do we have any comments from our committee members?
A little bit louder. A little bit louder.
All right. Do we have any? Thank you. Do we have any comments from our committee members? Kelly, then Wendy.
So I think one of my biggest concerns here is the use of the term pastoral counselor or Christian counselor or any form of faith-based counselor to escape the licensure process and then use that as a form of income, you know, by basically hanging out their shingle and saying, I'm a Christian counselor, I can do such and such, and, you know, I'm happy to counsel you for a fee. But it appears that is addressed in the changes in the regulations because it includes that provision which says no fee beyond the customary fee provided to the faith-based entity is not charged or received. So that's my comment.
Thank you, Kelly. Wendy?
I just have a question. Like, what is the recourse if they just ignore these regulations? So if they say, that's nice, BBS, that you said I can't collect a fee, I'm going to anyway. Like, what's the recourse?
Well, on those individuals, we usually start off with a citation and fine of $5,000 and then proceed from there. So depending on where the board would want to go with that, that's what we kind of issue currently right now. So
okay, that's helpful. Thank you.
Any other comments? I would agree that the LEP practice is mentioned, kind of going off of, you know, John's point earlier. I think that ultimately our goal is to align the licenses as much as possible. So even if there's no direct impact, you know, at this point, just because we are so different than the other 3, I think that at least mentioning them would be a good place to start so that we're involved in the conversation.
Yeah, let me explain the reasoning behind adding the Nursing Practice Act and the LEP Practice Act to Subdivision A. That subdivision is actually a carve out for other professional groups so that basically they're because sometimes there's overlap in scope of practice, like with a doctor, for example. We feel that LEPs should be in there because they're one of our other license types, and there obviously could be some overlap. The Nursing Practice Act is a little bit more questionable, but each of our 4 licensing laws in another place have a carve out that says basically this chapter shall not be construed to constrict, limit, or withdraw the Medical Practice Act, the LMFT Act, the Nursing Practice Act. So it mentions the Nursing Practice Act and those others. So we feel that it is appropriate to include it here as well in that list.
Okay, great. No more comments. Would anyone like to make a motion?
I have one more, Chris. The duty type. We do need to address the duty types. So
okay.
That sentence is, there was a question raised about whether in subsection B of, if you look at 4996.13, where it says pastoral or professional duties, is that an appropriate term? Should it just say pastoral? Should it just say professional? Should it say something else? The pastoral does sort of imply the Christian counseling, I think, only, so it might not be all inclusive. But the professional, I'm not sure. So we wanted to have a discussion about that because we weren't exactly sure what the appropriate word was there.
Is pastoral, I guess my question would be, is pastoral broad enough to encompass any religious or faith-based counseling? I mean, we could really get in the weeds and look at, I mean,
when I looked up pastoral, let me look it up again really quick. When I looked it up the other day, the dictionary cites, it implies that it's for the Christian church. So that, and we have decided to move away from stay instead faith-based counseling.
I think actually professional duties is really the.
So,
I mean,
how do we feel about just saying regular professional duties
for the established?
Yeah.
Or would, like, instead of pastoral with faith-based duties, would that make sense? Like regular.
Well, we were trying to link it to, I mean, you're really looking at what organization they're working for, whatever they're doing for that organization. Could be, pastoral, could be, I mean, I think the professional duties is kind of linking it, saying that they are acting within that entity's, purview. So even duties, I mean, professional duties, I think.
Right. This is Sabina. Would faith-based capture all of it if you didn't include pastoral? Because would that include all faiths, I'm assuming?
Well, I mean, we're already saying when providing faith-based counseling, so we're already defining faith-based counseling, and it's a matter of what are their duties, how are they operating. So, I mean, I think professional duties really does.
Professional duties, and then we say for an established and legally recognized faith-based entity.
Yeah.
So I think that would capture it.
Mm-hmm. Just take out pastoral or. Yeah, I think that works.
I think one of the traps that we kind of talked about when we were at the last board meeting when this came up, or maybe it was the last P&A meeting, I can't recall. The process that it takes to establish yourself as a recognized, I don't know if faith-based is the right term, but entity that like I want to make up my own religion type of thing. Then there's a process to do that, and then they're able to establish counseling around it, saying that they're working out of their state recognized, and maybe I'm backing myself into the corner by saying religion. Does that create a problem down the line if it's if we use a word like pastoral? I think that was directed towards our attorney friends in the audience.
Yeah, that's a good question. This is Sabina. That's a great question. I'm assuming pastoral was in there from the beginning of time, Roseanne?
Yes.
Right. And I'm assuming it probably also, at least back then, I'm talking, it sounds like I'm talking about like in the prehistoric times, but back then, I'm assuming it also, there was a lot less other faith-based type of counseling or other type of services than there are probably now, I'm guessing, right?
It's more apparent, it seems like.
Yeah, well, just based off of complaints we've seen. I mean, we've received consumer complaints occasionally, so that's kind of the measure of how often these services are, offered.
And are you speaking to, I think, Chris, are you, it sounds like it's not necessarily the pastoral professional duties, it's the legally recognized faith base. I think what you're kind of considering is like is there a possibility you could apply online to do the World Church, and is that legally recognizable? And then I'm a pastor of the World Church. I paid $5 for and then I could perform that, or?
Right.
Yeah. I mean, I guess, and again, I don't want to get caught in the weeds because we keep using, like faith-based words. But is the term broad enough to cover non-faith-based recognized organizations that want to provide counseling? Does that make sense?
Non-faith. I mean,
maybe professional duties is the correct term.
I think professional duties is. I mean, we have the exempt settings for other organizations that don't fit within this. I mean, this kind of gives. I don't know. I think professional duties does cover it. I think the key point is the legally recognized is kind of the key link for us to have that.
Yeah, there's that key, and then there's also they can't charge their own fee.
Mm-hmm.
The fee has to be paid. So you get that, $5 certificate, whatever. Now I'm a pastor. You have to be paid by that church, and I doubt that through that process there's a way for them to have that loophole.
Yeah,
and then legally recognized. I mean, there's certain tax. I mean, if we wanted to go further into this, I think it's legally recognized. We could go further in. I think maybe there's some language in the other ones where it's based on tax base. I mean, the exemptions and the way, and so there is the way to define legally.
Mm-hmm. I think that the charging of the separate fee. So if I join the World Church and set up my church, and then I start doing therapy, I can't charge a fee just to do therapy. I can't charge you $100 an hour.
Yeah.
For my services. That has to be part of the church.
And then that is the key component to it, because some of the complaints and the cases we've looked at, that's where it happens, where either somebody has, gone through and they've gone through seminary and got their pastoral, and may have been defrocked, or they still have their actual, they are a pastor, a rabbi, or whatnot, but they're not associated with any sort of organization. They're not, and they're just basically setting up shop and collecting fees directly. I think that's the biggest, like you're saying, it is one of the biggest things that I think within this to kind of really, that's the real strong point of this, is that collecting fees strictly from the client. So I don't know.
Thank you.
We talked around I don't know where we, so yeah.
No, if you guys are comfortable with the wording being broad enough to to not end up with unintended consequences, then I'm okay with it.
We think it's definitely an improvement over what we have, and so it's definitely, we think it's a good start. If there ends up being unintended consequences, then we might have to adjust it in the future or strengthen it. But
Or define,
yeah, this is kind of the best case scenario that we've come up with for now, that we've run it by legal and gotten some SME feedback on it. So we think this kind of stays in line without going, being too draconian, because we want to balance that too. But we think this walks the balance well. If it does not, then we might have to adjust it in the future.
there could always be room for improvement. Yeah, and we will have to watch, and yeah, definitely.
All right. Any other comments from our committee? Nope. Okay. Would anyone like to make a motion?
Good. That motion first.
The motion needs to say certain things though.
You want to help us with that, Roseanne?
Yeah. Okay. So the motion is going to be to direct staff to make discussed changes, which are going to be adding the LEP licensure and the Nursing Practice Act licensure to subdivision A of each of the proposed each of the proposed sections that are being amended. And then also to where it says in subdivision B, and I think that's in all of them. No, it's so where it's talking about that this article should not apply to any priest, rabbi, etc. when they're providing faith-based counseling services, part of their, where it says pastoral or professional duties, we're going to strike pastoral or that term in each of the three proposed sections being amended. And then the rest of the motion would be to also make any non-substantive changes and bring to the board for consideration as a legislative proposal.
So moved. Do we have a second?
Chair, I'll second.
Oh, sorry. Kelly, you can have it.
All right, we have a second. And then any further discussion? Any discussion, any comments from Shanti?
Yes.
Yes.
Okay, hello again. Shanti Ezra with CAMT. Just really wanted to thank Sarita, Roseanne, all staff for your research on the topic and also providing the proposed statutory amendments. Wanted to share that we're continuing to be supportive of clarifying language for those individuals providing faith-based counseling services as part of their duties to ensure adequate consumer protection. We've also had a chance to review the proposed language in the attachment A2 for LMFTs and things. We think it looks good and does a good job of listing the factors for individuals serving in a faith-based capacity. We do just have one suggestion for consideration, and that is to also include the word psychotherapy in addition to the word psychosocial that's already in the language as a description of services that they shall not state or imply. And then lastly, for the question on duty types language, I'm happy to circle back with our team and our attorneys, and I can get back to you, Roseanne and Sarita, offline about some of their thoughts.
All right, thank you, Sean. Do we have any comments from our remote participants?
This is the moderator. If anyone would like to make a comment on the motion or the issue, you can look for the hand icon that's typically in the bottom row of your WebEx screen. If you're on a mobile device, it might be behind the 3-dot other options button. And if you are a call-in user, you can press *3 to raise your hand. Each speaker will have 3 minutes with a 15-second warning. We do have a request for a comment from our call-in user. I'm going to send you a request to unmute. It will tell you, but you can also press *6 to unmute yourself. And you're unmuted. Go ahead.
Hi, this is Kathy Atkins with CAMP. I just want to thank the committee as well as Shanti. Shanti did a great job underscoring everything. And I just wanted to thank the committee for the conversation, because I'll be frank, I was kind of confused by this agenda item and sort of what it meant during Shanti's and my conversation. And a lot of clarity has come to me through the conversation and listening to the committee and staff. And so as this moves down the pipeline, I think it would be helpful for associations like CAMP to put out sort of educational, what does this really mean? How does this impact who? And so, you know, I think associations can help with that education as well. So thank you to Shanti and thank you to the committee and staff.
Thank you, Kathy.
And I do not see any further requests for comment. I turn the meeting back to you, Chair Jones.
All right, thank you, Margaret. Okay.
I had something that just kind of came to mind, because I know sometimes language around mental health can change a little bit, or I just want to make sure it's covered. So the portion that says the services provided are limited to counseling services provided in a religious or spiritual context and do not involve the diagnosis or treatment of mental health disorders. Does mental health disorders cover it? Just want to make sure, because I know sometimes language changes, or maybe just the DSM is everything considered a disorder. You know, I just wanted to double check that.
I think it covers it, unless someone feels differently. Minnie?
Okay.
Sorry, I see Kelly frantically looking at doing his lawyer analysis thing.
Yeah, no, I was thinking about what Shanti said. You know, is the word psychotherapy too broad? I don't know, you know. Yeah.
Yeah, do we want to include psychosocial, psychotherapy right there in B3? Psychosocial, the definition according to the dictionary, says definitions from Oxford Languages, is psychosocial is relating to the interrelation of social factors and individual thought and behavior.
I mean, I think it definitely covers more. I would.
So do we feel that psychosocial covers it, or do we want to include psychotherapy? It should include it.
I think it should. My personal choice. I honestly think it should include it. It does expand it, and I think actually if we look at our statutes and regs, I think we can find it in there too.
See, the thing is, I don't know that someone would use the term psychosocial in an advertisement, but I know that someone will definitely use the term psychotherapy. So I would tend to agree with Steve.
Yeah, this is Sabina. Whatever we use in our practice acts, we should be reflecting here. You know, we don't want to use anything new.
And we do use psychosocial also.
Right. But I'm not sure if that's encompassing all of it, or, I mean, I know we can like go into the weeds, like Chris said, like we're going to list everything under the sun, but would that be a loophole if therapy or other things weren't included?
I don't think we're not like a loophole. I think just adding the term it adds more strength to what we're saying here.
Right. I mean, like if you didn't list everything else in the Practice Act, you just listed the one. I just want to make sure you know what I mean, that we're not inadvertently leaving something out that's going to cause a problem later. But we can always revisit this later. And this is going to go to the board, so you all are going to see it again anyway, and you'll have a fresh set of eyes and other input. And the staff will have time to have worked on it and get some more input, that kind of stuff.
Yeah.
Well, and you know, again, I don't mean to throw a wrench in it. When you look at the LEP Practice Act, our form of counseling is referred to as psychological counseling. It's not referred to as psychotherapy. So I don't know if that makes a difference either. I think it's a broad enough term to encompass all of it. But you know, I mean, if we're talking about possible unintended consequences. Does that make a difference?
The other thing that we do also notice, we also call out there's a scope of practice. So if we needed to get more, in depth in that, we can look towards the scope of practice. So I think it is, both terms are somewhat broad, but I think it covers what we need, in my opinion.
Okay. Then, Christina, would you please take the vote?
I think we need to amend the motion.
So, yeah.
Do we have to amend it? I apologize.
Including the psychosocial along with psychotherapy.
Yes.
In the three acts that we are, in the three sections that we are amending, it adds psychotherapy after psychosocial. And we'll also take a look at how that language aligns with what's in the scopes of practice.
Would you mind repeating the whole motion one more time since it's been amended?
Oh, man.
Whatever.
Yes, I have it.
Thank you.
Okay, so it's going to be to discuss staff to make the discussed changes, which includes adding the LEP and the Nursing Practice Act reference to those in the first part of each of the three amended sections, which is subdivision A. And then to where each of the three sections are talking about this article shall not apply to any priest, rabbi, etc., as when they're performing faith-based services as part of their regular pastoral or professional duties. We're going to strike pastoral or in each of the three sections. And then when it's talking about in each of the three sections where they're talking about that the person cannot hold themselves out to the public by any title or description of services using the word psychosocial, we're going to add psychotherapy as one of the items listed right after psychosocial. And we're going to take a look at how that language there aligns with the scopes of practice of the other of each of the professions that we're making amendments for. And then also staff will make any non-substantive changes, and then we'll bring to the board for consideration as a legislative proposal.
We need a new first.
So does anybody want to take that motion?
I'll make the motion.
Oh,
Chris,
Christine,
we're having a hard time hearing you.
Sorry. Kelly, did you want to second it after Wendy?
I'll second.
So now that we've done it, this is first.
He still can't hear you, Chris. No, but I was like, come on.
Is that any better?
I'm like, no.
Yes.
Yeah, that's better.
Okay. So this is for Sabina. Now that we have an amended motion, do we need to go back for discussion?
Yes.
Yes, we'll go ahead and check in with the public one more time on this amended motion.
Okay. Shanti?
Shanti, anything? We're going back for comment, Dina.
No comment, just appreciate the discussion. Thank you for including psychotherapy for all the reasons that everyone's already discussed.
Perfect. How about from our mode participant?
And this is the moderator. If anyone would like to comment on the amended motion, you may look for the hand icon and click that to raise your hand. And call-in users can press *3 to raise their hand. I do not see any requests for comment. I'll turn the meeting back to you, Chair Jones.
Thank you. All right, let's vote. Christina?
Chris Jones,
Yes.
Kelly Ronasigi,
Yes.
Wendy Strack,
Yes.
John Sovek.
Abstain.
Motion carries.
All right. Thank you. Next on on the agenda is the discussion and possible recommendation regarding Senate Bill 775 amendments. Roseanne, would you please give us the overview?
Yeah, thanks, Chris. So SB 775 is the board's sunset bill. It's being sponsored by Senator Ashby, who's the chair of the Senate Business and Professions Committee. The bill proposes extending the board's sunset date to January 1, 2030. And the board at its May meeting took a support position on that particular provision of the bill. The board is also sponsoring several amendments in SB 775 related to its practice acts. One of these amendments that the board is sponsoring proposes extending the sunset date of the temporary practice allowance that we currently have. Right now that expires January 1, 2026, so the board is proposing to extend that to January 1, 2030. So that's one of the board's proposed amendments. The temporary practice allowance, just a little bit quick refresher, that's the allowance that became law in 2023, but the board sponsored it. It allows a 30-day temporary practice allowance to qualifying therapists licensed in another U.S. jurisdiction to continue treating existing clients who are visiting California or relocating to California. Because it was a brand new allowance, the board decided to include the sunset date of January 1, 2026 originally, so that we could reevaluate it at the board's sunset review process. That was reevaluated, and the board decided during the proposing of SB 775 that it would like to extend the termination date of the temporary practice allowance by 4 years till 2030. So that was put into the bill. As part of the background paper for the board sunset review that they did in March, both Senate and Assembly Business and Professions committees noted that it would be helpful to understand how the board enforces the 30-day time frame of the temporary practice allowance and whether the board believes out-of-state practitioners may be providing services to their clients in California beyond this time frame. And so most of the people, we don't really have any way of knowing for sure, but this allows us at least to track and let people know when their expiration date is. The way that we would find out is if we were to get any kind of complaint, and then it would be unlicensed practice if they were out overstaying their 30-day temporary practice allowance. And so this sort of was a step in creating a process to sort of allow for these types of situations. The committee, the Business and Professions Committee, have requested an additional amendment be added to the temporary practice allowance statute in SB 775. And that's found in Business and Professions Codes 4980.11 for MFTs, 4996.16.1 for LCSWs, and 499.23 for LPCCs. The amendment would strengthen accountability of an out-of-state licensee providing services to a client by requiring them to submit a signed statement under penalty of perjury, acknowledging the board's jurisdiction and agreeing to comply with California law. So right now the law says that it basically if they provide services under this section, they make the application and everything, they're deemed to have agreed to practicing under the jurisdiction of the board and being bound by the laws of the state. This is making them actually sign a statement under penalty of perjury, acknowledging that they're going to subject to the board's jurisdiction and agreeing to be bound by the laws of the state. So it's a little bit of a strengthening there. It's language that the committee asked for, has already put in, but the board's last meeting was in May of 2025, so the board has not had an opportunity to review this. So that's why I'm bringing it to you today, so that you can be aware of it. Note the markup in the packet is what the actual law changed. The law that's actually in the text of SB 775 today looks different from the amendments in the attachment in the memo. The memo is actually what's changing. The attachment has some language from a previous version of the bill where I asked for a clarifying amendment. So the language I included in your packet is what the actual change is. So staff recommends that the committee conduct an open discussion regarding the proposed amendments and recommend that the board take a support position on those particular amendments. We already have a support position on the other Senate or BMP committees pieces of the bill that they are running So this would just be a support on another new piece that they have placed in. I'll open it up for discussion.
All right, thank you, Roseanne. Any comments from our committee members? No, seems pretty straightforward to me too. Would anyone like to make a motion?
And the motion would be to recommend to the board to take a support position on the amendments to the 4980.11, 4996.16.1, and 4999.23.
This is John Sobek. I so move.
Do I have a second? All right, I'll second. Any further comments? Kelly's winding up. No, we're good? Okay. All right. Shanti, any comments from you?
Shanti Esrin with CAMP. Just wanted to take the moment to thank Roseanne, thank staff, and thank the committee members for your work on the bill, sponsoring the different amendments that include extending the sunset dates that you had just gone through, and also including the allowance for VBS to adopt the AMFTRB national exam via regulations. No concerns with the requested additional amendment from the legislative committees, and CAMP will continue to support the bill.
All right, thank you, Shanti. Any comments from our remote participants?
This is the moderator. If anyone would like to make a comment on the motion or the issue, you can look for the hand icon at the bottom of your WebEx screen. Our call-in users can press *3 to raise their hand. Instructions are on the screen. Any comments on the motion or the issue? I do not see any requests for comment. I'll turn the meeting back to you, Chair Jones.
Thank you so much. All right, Christina, would you please take the vote?
Chris Jones,
Yes.
Kelly Ronasini,
Yes.
Wendy Strath,
Yes.
John Sobek,
Yes.
motion carries.
Wonderful, thank you. All right, next on the agenda is the update on board-sponsored legislation. Roseanne, would you please provide us the overview?
Yeah, just a status update on some of the bill proposals that the board has either sponsoring or has taken a position on. We just talked about SB 775, which is the board sunset bill, and the bill that we're sponsoring a lot of provisions of. That bill is moving along nicely. It is passed both its policy committees in both houses and now is in its final committee, which is the Assembly Appropriations Committee. The legislature's on break right now, so they will come back on August 18th. So that bill is moving along just fine. AB 489, which is the bill that would extend a board's authority to take action to a entity that develops an AI generative if it uses prohibited terms that violate the board's jurisdiction, that the board's supporting that bill. That's also in the Senate Appropriations Committee. What else? The board opposed AB 427, which is the Social Work Interstate Compact bill this year. That bill is now a 2-year bill, and that's pretty much the highlights. So the rest of the status of the bill positions are in your packet.
Wonderful, thank you. Any comments from our committee members? All right. Sorry, my quiet again?
No, we can hear you now.
Okay. Did Shanti have any comments?
No comments, thank you.
Nope.
Thank you. I just can't see him very well. Any comments from our remote participants?
This is the moderator. If anyone would like to make a comment, you may look for the hand icon at the bottom of your WebEx screen, or you may, our call-in users can press *3. Are there any comments on the issues? I do not see any requests for comment. Shall I close? I can close that and turn the meeting back to you, Chair Jones.
Thank you so much.
You're welcome.
Okay, next on the agenda is the update on the board rulemaking proposals. Christy, would you please provide us with the overview?
Yes. Okay, so the first is the disciplinary guidelines. We're getting very close here. So it's currently, I believe, in the director's office undergoing review. So it's moving through that final phase. So we're hoping to get that over to the Office of Administrative Law sometime here in the next few weeks. We did ask for an implementation date of July 1, 2026 to give us a little time for implementation. So we'll be watching that closely. The telehealth regulations were submitted to the Office of Administrative Law for final approval on July 8th. So they have 30 days for that review. So we haven't heard back from them yet, but we expect to be soon. For the continuing education regulations, I'm still working on some requested edits to the documents that are required as in part of the production phase review that happens after board approval of the language. So still working on some of that. The advertising regulation proposal, we had a 15-day comment period for modified text that ended July 1st. And we do have a comment to be reviewed by the board at its August meeting, so we'll look at that. And then the English as a second language, additional examination time, that's still being prepared for production phase review, but I believe we're very close to getting that submitted. And that's all I have.
All right, thank you so much, Christy. Any comments from our committee members?
Oh, I'm sorry. I just realized, Steve, I didn't include the fee regulations. So, do you want to update us on where that is?
They're in the production. I guess it's called production phase. We currently are drafting those and working with legal and budgets. I think that would be ending up in the production phase coming up.
Pre-production.
Yeah. So.
At this point, so okay.
And those are looking to be established. We're hoping to have that start date on July 1st, 2026. So you will be seeing those coming up.
All right, thank you. Any comments from our committee members? All right, any comments from Shanti?
No comments, thank you.
Any comments from our remote participants?
This is the moderator. If anyone would like to make a comment, you may look for the hand icon at the bottom of your WebEx screen, and our call-in users can press *3. Are there any comments on this issue? I do not see any requests for comment. I turn the meeting back to you, Chair Jones.
Thank you. All right, next on the agenda are suggestions for future agenda items. Do any of my esteemed committee members have any suggestions for future agenda items? Okay. Shanti, any suggestions for future agenda items?
No suggestions.
How about from our remote participants?
And this is the moderator. If anyone would like to suggest an agenda topic for next meeting, you may look for the hand icon at the bottom of your WebEx screen. If you're on a mobile device, that hand will be behind the 3-dot other options. Any suggestions for future meeting topics? I do not see any suggestions and turn the meeting back to you.
All right, thank you. Next on the agenda is public comment for items that are not on the agenda. As a reminder, the board may not discuss or take action on any matter raised during the public comment section, except to decide whether to place that matter on the agenda of a future meeting. Do any of my committee members have comments for items that are not on the agenda? John.
I just want to publicly recognize and thank the staff for being really cognizant of creating gender neutral language. We're updating all of the work that we're doing. There are some spots today where I noticed it again, and I really appreciate the effort you're all making to catch this and make all of our practices more gender neutral as we're doing public facing documentation.
Thank you, John. Any other comments? Okay, how about from Shanti? Any comments?
No comments, thank you.
All right, how about from our remote participants?
And this is the moderator. If anyone would like to make a comment on anything that was not on the agenda, you may look for the hand icon and click that to raise your hand. Any comments? And I do not see any requests. I'll turn the meeting back to you.
Wonderful, thank you. Our next agenda item is adjournment. I want to thank everybody for participating today. As a reminder, our next board meeting will be on August 21st and 22nd in Newport. We hope to see you all there. Everybody have a great weekend.